Hi, everyone. Thank you for joining us, and welcome to today's program entitled The New PTAB Rules, How to Win in the Expanded Pre-Institution Battleground. Before I turn the presentation over to our speakers today, who will be our Foley partners, Steve Maebius and Linda Hansen, I'd like to go over a few housekeeping items with everyone. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. If we do run short on time, please be assured we will follow up with you via email after the program regarding your question. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can obtain a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after this web conference. If you did not supply your CLE information upon registering, please send an email to me, Allison Jones, at ajones@foley.com. That's ajones@foley.com. To be eligible for CLE, you will need to be logged into this ON24 session for the entirety of today's program and also answer a polling question during the program. Please note that certificates of attendance will be distributed to eligible participants via email approximately 8 weeks after the web conference today. As a final note, those seeking Kansas, New York, and/or New Jersey CLE credit are required to complete the attorney affirmation form in addition to answering the polling question during this program. A 5-digit course code will be announced during the presentation. Please email the code with your completed attorney affirmation form to me. Again, my name is Allison Jones, and my email address is ajones@foley.com immediately following the program. A link to the form was included in your confirmation email, and a copy is also available in the resource list widget. Thank you so much, and with that, I will now turn the program over to our speakers. Steve and Linda, take it away when you're ready.
Thank you, Allison. Thank you all for joining us. This is Steve Maebius. I'm a partner with Foley in the Washington, D.C. office and a member of our Patent Office Trials Group. And I've been involved with IPRs on both the petitioner and patent owner side, mainly in the biotech and pharma area. Linda?
Yes, my name is Linda Hansen. I'm also a partner with Foley and Lardner, and I'm in the Milwaukee office. Unlike Steve, I am full-time IP litigation, focusing on patents, and I have been involved in a number of IPRs as well.
All right, we're going to briefly go over our agenda, and we'll start with a little bit of background on how these new rules came into being, and then we'll go over the major rule changes by area and talk a little bit about how they're going to impact practice in AIA post-grant proceedings. And we'll try to also focus a little bit on how each change in the rules may affect the balance of power between the patent owners and petitioners, and where each side may get a little bit of an advantage from the changes in the rules. And then with any remaining time that we have today, we'll be glad to get to your questions and try to answer them the best we can.
What led to the rules package actually goes back a little bit before the rules, and that is what led to the America Invents Act, because this is part and parcel of that. There was a concern, according to Congress, that there were, excuse me, that there were poor quality patents out there, many of them used by non-practicing entities, against manufacturers and others in the chain of title to products, and that were being used to, take money away from them. That was part of it, and of course we were going to be joining the rest of the world in a first to file rather than first to invent. And then once the AIA went into place, of course, it's got brand new procedures, brand new ways of doing things, and with all laws, there are always some unintended consequences. And so one of the things that we found out was there were some very high invalidation rates of patents going through IPRs and covered business method challenges. In fact, as of January 31st, 86% of the IPRs involved the invalidation of at least one claim, and 97% of the CBM petitions ended up invalidating at least one claim. Now that seems really high, but covered business method patents after Alice, I think that it should have been expected that there would be a high invalidation rate. And one of the things to keep in mind is that the same panel that decides whether or not to institute the IPR ultimately makes the final decision as to whether or not the patent claims are valid. And so if they see what they believe is a valid challenge and they decide to institute, it's not entirely surprising that they might invalidate at least some of the claims. There were also some concerns by patent owners primarily, but also by petitioners, that there was procedural gamesmanship going on in the AIA trial process. Now, that's not particularly surprising either when you consider you've given a bunch of new rules to lawyers, and they're going to try and find ways to make this new procedure work best for their clients, and they might be pushing on those rules a little bit to see exactly where they fall. There was also a concern about claim construction. Of course, in an IPR, we use the broadest reasonable interpretation, and in trials, we use a Phillips-type analysis for claim construction. There were some questions as to whether or not that was the best way to go. And, of course, we had the page limits on the briefs that were being submitted. And I know that, when I was in high school and I was told I had to write a 3-page paper, I struggled to make it 3 pages long. And now that I'm a lawyer and I'm told I can only write 80 pages, I struggle to get the brief down to 80 pages. So a lot of us ran into issues where perhaps we wanted to include a helpful chart or a graph, and that pushed us over the page limit. So could we afford to do that? And you don't get to play games when you're looking at word counts as opposed to page limits. So those were a number of the issues that were of concern. The USPTO sent people around the country, met and listened to people who were interested to find out what they wanted, and they came up with the new rules package, which hopefully takes care of some of the concerns. But in some of these, the Patent Office decided to stick with exactly what they had started with.
So the effective date of the new rules is May 2nd, and the announcement, which contains the final rules, of course, came out on April 1st, and it's in the Federal Register at volume 81, issue number 63, starting at page 18750. The new rules are going to apply on May 2nd to any new AIA petitions filed on or after that date, and also to any ongoing AIA preliminary proceedings or trials that have already been instituted as of that point in time. So it's important to keep in mind that this is not just applicable to new petitions, but also to ongoing proceedings. So if you have a preliminary response that's going to be due after May 2nd or on May 2nd, presumably you'll be able to take advantage of these new rules. There are going to be additional explanation of how the rules are being implemented in the trial practice guide. So we should definitely keep our eyes open for those changes as well. We don't know the exact date that the trial practice guide changes are coming out, but the Patent Office has said that it will be very soon.
All right, some of the major changes to the rules. The first one is the one that I think is getting the most attention, and that is that now the patent owner can put in their preliminary response, that is before IPR is instituted. They can use new evidence, a declaration from an expert or somebody, and hopefully in that way avoid institution. Of course, because institution is seen as a way to kill off a patent, if you can avoid institution, you avoid getting yourself in a position where you could lose the patent. I think it was Judge Rader, the former Chief Judge of the Federal Circuit, said that the judges of the PTAB were acting as death squads, killing property rights. So this may be something that would keep a matter from actually being instituted. The petitioner then may seek leave to file a reply for a preliminary response. And that's entirely new. Then the pre-institution factual disputes will be resolved in the petition's favor. So, for example, the patent owner puts something in to respond to the petition owner's the petitioner's petition. The question is whether or not it will be enough to, the patent owner's response to that will be enough to stop the action from proceeding. And in that case, and that case only, the patent trial judges will be looking at whether or not it raises a factual issue sufficient to stop institution. And that is resolved in the petitioner's favor. Then we've got a Rule 11 type certification. For anyone who's doing litigation, that wouldn't be a big surprise. We've been used to that. And it also brings in a Phillips type claim construction for patents that are going to be expiring 18 months or less from the institution. And now, in addition to having page limits on the major briefs, we're also going to have word counts.
So let's talk a little bit about the first big change to the patent owner preliminary response. And this really is a new opportunity for the patent owner to present a rebuttal declarant in their preliminary response, which up until this point a patent owner has not been able to do. And this could involve identifying, retaining an expert, and preparing an expert declaration specifically tailored to address the petition and any expert presented in the petitioner's petition as part of the preliminary response. But there's no change in the time limits here. The patent owner is going to have to work pretty quickly because there's only 3 months from the date that a filing date is accorded to the petition for the patent owner to file its response. And if the patent owner's preliminary response may involve obtaining rebuttal evidence, for example, conducting an experiment, if a petitioner has offered some evidence of, let's say, inherency, it may be a challenge to get a set of experiments done in a 3-month period. It may be a challenge to gather evidence to try to swear behind a reference if one of the references in the petition happens to be a 102A reference or a 102E reference. So this is both an opportunity and a challenge for the patent owner in the sense that you have to work quickly, but at least now you can present new declarations as part of your preliminary response to address whatever evidence or declarations are provided in the petition. One thing that I'd like to point out, this is not a change in the rules, but already is available under the existing rules. The patent owner can use confidential information in a preliminary response. In order to do this, you do need to meet and confer with the petitioner and agree on the terms of a protective order, which the board has a default protective order that's available in the trial practice guide. And you can simultaneously file a preliminary response, a protective order, and a motion to seal. So if the patent owner wants to include evidence that they hope to keep confidential, they can avail themselves of this route. The caveat is that the board may not ultimately grant a motion to seal, and even when the board does grant motions to seal, they reserve the right to discuss evidence that's been submitted as part of their decisions if they feel that it's necessary to explain the basis of their opinion. So it's not a guaranteed way to keep information confidential, but it at least is a procedure that may allow a patent owner to rely on sensitive information. And sometimes, for example, in the pharmaceutical area, companies may have clinical data or test data that's helpful to support patentability, and they may choose to use it in this way. One example is the IPR 2014-00377, which I cited in the slide. Another interesting change that may occur is, this is in the Patent Office comments, in the response to the comments in the Federal Register notice, but the Patent Office indicated that a panel in its discretion may order some limited discovery, including cross-examination of witnesses before institution. So there does seem to be at least a small possibility that the Patent Office would allow a deposition prior to institution. It seems like this is going to be reserved for a pretty limited set of circumstances, and it does appear that they might possibly order limited discovery. It doesn't appear that the Patent Office is inviting petitioners to request this. It just says that they may order limited discovery in the panel's discretion. So I think that parties can assume that there's probably not going to be very many cases where this is permitted, but the Patent Office is indicating that the panel has the right to do it. Another question that was raised in the comments in response to the proposed rules is what happens if the patent owner does not rely on pre-institution testimony during trial. So let's say they presented a declarant who addressed various alleged grounds of unpatentability, and then there's an institution decision that only relates to one grounds of unpatentability, and the patent owner doesn't want to maintain the declaration testimony they used in the preliminary response. In this case, the Patent Office responded to the public comment that the deposition would not be automatic post-institution, but it would only be allowed under the additional discovery procedure. So that's something to keep in mind, is that there's not a guarantee that the patent owner declarant in a preliminary response will be deposed after institution if the patent owner doesn't continue to rely upon that testimony.
With regard to that last point about filing, the patent owner filing their preliminary response and their evidence, one of the things that I think of as I go through this is, how would I counsel a client if they were in fact the patent owner and were saying, should we file this testimony with our preliminary response? Particularly where there are situations where the information that has to be used to really have a chance of stopping the institution, where that's confidential, and if the petitioner doesn't agree on the protective order, I'm going to be really nervous about simultaneously filing my preliminary response with the proposed protective order and motion to seal, on the chance that if the motion to seal isn't granted, suddenly the confidential information is public. And I'm going to be particularly concerned because with regard to institution, a tie goes to the petitioner. And so if looking at what the petitioner has put forward and seeing what I think we're going to gain from filing the confidential information, I might just advise my client not to do it. There certainly is a risk here. I don't know how things are going to end up. I don't know if the judges will, as a matter of course, keep things sealed, grant the protective order. But at least until we start seeing decisions on this particular issue, this new issue, I think it is something that we all need to consider when deciding whether or not that preliminary response should include testimony. Now, as Steve mentioned, the petitioner may seek leave to reply to the patent owner's preliminary response. I would think, as a matter of course, if the patent owner is putting in testimony with the preliminary response, it's going to raise some new issue. It's going to be something that the patent owner is going to take a look at and go, I want to respond to that. I want to say something. And usually in trials, in district courts, if someone introduces evidence after you've filed your last brief, you can argue for a chance to reply or a surreply or whatever it might be, depending on which venue you're in, which jurisdiction you're in. They say, well, there's new evidence, so you get a chance to respond. But I look at this and I think, this is on a case-by-case basis, and they're not going to want to grant an opportunity to reply on every single one. So it's difficult to really know what kind of a test they're going to use to allow a reply brief. If they use the test that there's some new evidence and you want to reply to it, they would be granting the opportunity to reply in almost every case. So I think it's fair to assume that that's not going to be the test. And until we start seeing how the judges rule on these motions for a reply, I don't really know what the test is going to be. And it's something that I think we all need to watch, see what the decisions are so that we know what the likelihood is if we have a client that wants to file a reply brief on this.
And just one final point before we get to this next slide about the petitioner reply. This is definitely one of the biggest question marks in the new rule changes. And I think that petitioners will have to move very quickly if they do want to seek leave, because there's only 3 months between the filing of the patent owner preliminary response and the board issuing its decision on whether to institute. And so the board's going to need a certain amount of time to be able to review these extra papers that are being filed. So I think it's going to be very important for petitioners to act quickly if they want to obtain leave to file a reply.
I think Steve raises a really good point, which is you can file this additional information. It's going to take a lot of time, effort, and money to put it together. So we have this great new procedure, but the length of time for a PTAB trial hasn't changed. So we have a new thing that we can do, but it doesn't change the deadlines.
Exactly. And that brings us to sort of the third component of these pre-institution changes, which relates to resolving factual disputes in the petitioner's favor. So for any patent owners who are hoping they can just file a rebuttal declaration along with a preliminary response and automatically avoid institution, I think this is the change that makes that unlikely to happen. If there's a genuine issue of material fact created by the patent owner's testimonial evidence, it will be viewed in the light most favorable to the petitioner for purposes of the institution decision only. And so simply filing a declaration that just contradicts the statements of a petitioner's expert may not be sufficient to create a genuine issue of material fact. And in fact, the Patent Office has noted that in the response to the comments in the Federal Register notice. So you might ask, well, should we really put testimony into the patent owner preliminary response if disputes are always going to be resolved in favor of a petitioner? And it's important to note that the Patent Office also indicated there's no negative inference drawn if a patent owner does forego this opportunity to submit new testimony or new evidence. So I think this places a certain amount of effort or onus on the patent owner's part to be selective in deciding when it will really be valuable to submit a rebuttal declaration or what kinds of evidence will be persuasive to prevent institution.
Steve, can I just make a quick comment?
Sure.
One of the things that struck me when I read that no negative inference is given or is drawn if the patent owner forgoes putting in new testimony. And I think that's great, and I like the fact that the rule says it if I'm representing a patent owner. But I also know that there are studies, juror studies, in criminal law where they talk about no negative inference if the defendant decides not to take the stand. And although the jurors are told there should be no negative inference if the defendant doesn't take the stand, studies have shown that, in fact, jurors do give a negative inference for that very thing because they think, if I was sitting here and someone wanted to send me to jail, I'd sure want to testify. So the question in my mind is whether or not the PTAB judges are going to be able to make sure that there is no negative inference. Because in a sense, you're not saying, hey, there's not really a question. This patent is great. Shouldn't institute. And if you forego your chance to do that, you know, we can't read the minds of the PTAB judges. So there's, I think, still a little bit of risk in that.
That's a great point. And by the same token, the patent owner doesn't have to file a preliminary response at all. In fact, it's optional to file a preliminary response, but the statistics show that there's a less likelihood of institution when the patent owner does file a preliminary response. So I think overall, these opportunities can be valuable as long as patent owners are presenting good arguments and good evidence.
Yeah, you know, we are bound to represent our clients zealously. And so if you're balancing do I put in new evidence or do I not? I would almost think you have to, unless there's going to be some confidential new evidence that might cause other problems, as I mentioned earlier. Other than that, I think you almost need to put something in.
Yeah, it does seem like a good opportunity that in most cases people will want to take advantage of. A couple more thoughts on this aspect of resolving factual disputes in the petitioner's favor. There have been a number of PTAB decisions that relied on the fact that the declarants made conclusory statements. And I think the board carefully reviews declarations, and they look to see whether the statements are carefully reasoned and are they supported by exhibits with solid evidence, or in some cases they find that the experts are making sweeping statements which they refer to as conclusory in a lot of their opinions, and they don't give it much weight. And just one example of this is IPR 2016-00011, where the board recently found that there was an inadequate basis for institution because the petitioner's expert had made too many conclusory statements about the prior art. Well, I think the same situation can occur with patent owners who are trying to take advantage of this new rule. When they submit rebuttal expert declarations in their preliminary response, they should be careful about not having their experts make conclusory statements, because if they simply are providing opinions that aren't carefully reasoned or well supported by the evidence, you run the risk that the board may say, well, the patent owner's declaration is conclusory, and we're not required to give weight to that. And also, because the disputes are going to be resolved in the petitioner's favor, it's even less likely that the patent owner preliminary response in that situation will prevent institution. So all of this is going to bring a sharper focus to the question of whether the expert declarations are well-reasoned and carefully supported in the statements that they're making.
Now we get to the Rule 11 type certification. And if you do litigation, this is something that you're familiar with. If you're not usually doing patent litigation, you might not remember this from law school. But Federal Rule of Civil Procedure 11 essentially says that if an attorney signs a document and submits it to court, the attorney is saying there is a good evidentiary basis for this, it's supported by the law, or a reasonable change in the law, and it's, that's supported by it. So you're putting yourself on the line to a certain extent. And here, the Rule 11 certification is that, to the best of your knowledge, information and belief formed after inquiry reasonable under the circumstances, which of course means you can't simply file something because someone said, oh, you got to file this because we should win. You've got to actually take a look at the patents, take a look at the prior art. You've got to do an analysis sufficient that says that what I'm submitting, I actually believe is true. So you're saying it's not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of the proceeding. I do know that while it raises costs if there is concurrent litigation, it generally doesn't slow down the trial court proceedings, because a lot of judges, particularly in the Eastern District of Texas, aren't granting stays pending the outcome of the IPR procedure. All right, then you also are saying that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. And there you might be able to say, you know, patent infringement is a tort. In other torts, we've looked at this, or there's some other reason based on maybe a new Federal Circuit decision or something that indicates, hey, they're going in this direction. They might not be there yet, but I think it's a reasonable argument to make here. And you're saying the factual contentions have or likely to have evidentiary support. So it may be a situation where the other side has the evidence that you need to be absolutely certain, but you've got a reasonable belief that they do in fact have that. Not just a, hey, maybe they have it, but you actually have some reason to believe that they do have it, and it's likely to support your factual contentions. And this also applies to your denials. You can't simply deny something unless you've got a reasonable factual basis for that denial. One of the things that might be a question to some of you is how this interplays with Rule 42.51, which is the discovery rule for AIA-type hearings and trials. And Section B1 III talks about discovery. And what it says is, unless previously served, a party must serve relevant information that is inconsistent with a position advanced by the party during the proceeding concurrent with the filing of the documents or things that contain the inconsistency. This requirement does not make discoverable anything otherwise protected by legally recognized privileges such as attorney-client or attorney-work product. This requirement extends to inventors, corporate officers, and persons involved in the preparation or filing of the documents or things. So when you're working on the petition or now on the patent owner's evidentiary response, one of the things that you need to do is talk to your client and ask, are you aware of any documents, any evidence that you have that is inconsistent or goes against the argument that we're making here? Now, this is something that those of us that do litigation have seen with the discovery rules, for example, in the Eastern District of Texas, which is if you've got it and it might be relevant, you better produce it. If you've been doing patent prosecution, it's not quite the same. So consider the fact when you're putting together your briefs and your evidence in an IPR or in a petition to, or in the pre-institution phase, that if you are aware of any evidence that is held by your client, the inventor, corporate people, their officers, people who are preparing the documents, if you're aware of anything that's counter to that, you better take a real close look at that and make sure that you've got a reason that it should be discounted, it doesn't really apply in this situation or something else, so that you can accurately make your Rule 11 type certification. Now, along with the Rule 11 type certification comes some new authority to the board to sanction people who violate it. The sanctions, as one might expect, are imposed on practitioners and parties. The one that surprised me was they can't be imposed against law firms. So when you sign the documents, if you're signing something that you shouldn't be under Rule 11, you may be the one who's liable for the sanction. So it probably behooves all of us to check with our firm's insurance carrier and find it and our firm and find out where we stand on that. Of course, this would be done within the course of your ordinary employment, so there could be firm liability anyhow. But it's something to be aware of. The sanctions don't go against the firms, just the people who are actually involved, the parties and the practitioners. Now, in order to file a motion for sanctions, you have to permit the person or the party against whom you're intending to request sanctions to either withdraw or remedy the action that you believe was improper. And you can't even file or present this to the board if the challenged documents, papers, claims, defenses, contentions, denials, whatever it is withdrawn or appropriately corrected within 21 days after notice or the time set by the board. So in other words, you have to get permission to file a motion for sanctions, and you've got to notify the target of that motion and give them 21 days to fix the problem. Now, a motion for sanctions can be instituted by the opposing party, the one who's requesting the sanctions, and it can also be instituted by the board. And I have to say that if I am the one who a motion for sanctions is filed against, and it's by the board, I'm going to be really concerned about that. If it's filed by the other party, I need to make sure I've got a good defense. But if it's filed by the board, I have to assume that you've really gone off the deep end on that one. Of course, it has to be authorized by the board, but if they're the ones who decided to institute it, I think it's a fair guess that they are going to authorize it. And then the board may award to the prevailing party the reasonable expenses, including attorney's fees incurred for the motion. And this is always a little tricky because what are the reasonable expenses and what are the reasonable attorney's fees? One of the things to keep in mind if you decide to file such a motion is then you've got to put your bills into evidence and say this is in fact reasonable attorney's fees. And sometimes the clients don't like the other side to know what it is that they are charging their client.
Moving on to claim construction, a little bit of background here is that initially people criticized the adoption of the broadest reasonable interpretation standard in AIA proceedings after it became clear that in practice it was very difficult to obtain amendments during the course of an AIA proceeding. And that's because of the high standards imposed by the board, which are necessary given the abbreviated procedures for conducting these proceedings. And one of the early appeals to the Federal Circuit challenged the use of BRI in these proceedings, and that was the Quazzo case. And ultimately, the Federal Circuit upheld the board's ability to apply broadest reasonable interpretation. However, there was a strong dissent, and subsequent to the Patent Office's proposed rules on this, the Supreme Court granted certiorari in the Quazzo case. So probably by around June of this year, we will get a ruling from the Supreme Court on whether or not the broadest reasonable interpretation is appropriate given the practical limits on being able to amend your claims during AIA proceedings. But at least for now, there's no change. The Patent Office decided not to address broadest reasonable interpretation for the vast majority of cases. Now, they did provide one exception in these new rules, and that is only for patents that expire within 18 months of the notice of filing date being accorded to a petition. So if a patent is being challenged in its final 18 months of its term under the AIA, a party, either party, may request by motion that a Phillips-type claim construction the same as the district court uses in litigation, be applied to that patent. There's a time limit of 30 days from the petition filing date for either party to do this. And the panel will have discretion as to whether or not to grant it in this particular case. But they can ask for briefing if the party files one of these motions. And the idea is that the board should be able to decide prior to institution and hopefully even before the patent owner preliminary response is due, whether or not to grant the motion for applying a different claim construction, such as the Phillips type construction to the claim. So again, this is only for those patents that are very near the end of their terms, and we'll have to see what happens with the quasi-Supreme Court case as to whether or not the broadest reasonable interpretation is going to be retained.
Now, the title for this next slide is a little bit misleading because it talks about word count instead of page limits. And that's simply that you can use word count instead of page limits now on your briefs, but you can choose to go either way, either using the page limits or using the word counts. The parties to AIA trials complained about how difficult it was to comply with the page limits, and as a way to deal with that, they would have extensive citations.
I think we may have just lost Linda, so let me pick up until she's able to reconnect. Apologize for the technical difficulties there. But by picking up on the word count instead of page limits, this was the Patent Office's effort to address the situation and try to bring clarity to it. And I think being able to use words as an alternative basis for measuring the limits is certainly easier, just to have the word processor application tell you how many words have been used. And the one other important aspect is that the claim chart words will also count.
This is Linda. Sorry,
Hey,
the battery died on my headset, and suddenly, I think that's what was beeping. Suddenly, everybody was gone. I'm not sure what you said, but one thing that I feel as someone who's writing briefs, I like the idea of a word count because so often in these technical fields, a chart or a graph or some kind of drawing is really helpful. And now you don't have to worry that putting in that chart or graph is suddenly going to take up a page for 500 words, for example. So I'm really happy to see the word count.
The seventh change we wanted to cover, and this is not a huge change here, but you have a little more time to review the other side's demonstratives. The new rules provide 7 business days prior to the final hearing that the parties have to exchange demonstratives, and most of the time that involves PowerPoint slides or some similar type of exhibits that are going to be handed out or used at the final hearing. And 7 business days gives you a little bit more time to meet and confer and resolve any disputes in case there are exhibits that are being mischaracterized or anybody who's, I guess, gone too far and taking testimony out of context. You'll have an opportunity to look at each other's demonstratives and present those objections, try to work them out. And if you're not able to, you still have a little bit of time to go to the board in order to get resolution on this point. One thing to keep in mind, just as a strategic point, is the issue of telegraphing your argument, and you're now giving, if you have a very detailed set of slides, you may be giving more advance warning to your opponent, who can then prepare better to defend against it. So you should think carefully about what you choose to put into demonstratives versus what you just rely on at the hearing. For example, displaying an actual exhibit from the record wouldn't be something you would need to exchange in advance. But on the other hand, a PowerPoint slide that's summarizing testimony of a witness, that is something that you would have to present beforehand. So I think you can think carefully about what goes into the demonstratives versus what you present based upon actual exhibits at the final hearing, to avoid giving too much forewarning to your opponent.
Finally, the question is, who's better off under the new rules, the patent owner or the petitioner? And I think actually the answer is it cuts both ways. First of all, I think that the idea of being able to submit new testimonial evidence to try and avoid institution is seen as a big positive for patent owners. The question in my mind is it really going to work out that way? And I think we're going to need maybe a year so that we can look at the institution numbers to determine whether or not they change with this new ability. And then, of course, something that goes to the petitioner, which is they may be able to seek leave for a reply to the patent owner's preliminary response. And we don't know, again, how frequently those will be granted, so we don't know how big of a benefit that is. Of course, it is in petitioner's favor for the material factual disputes are resolved in the petitioner's favor for institution. The Rule 11 type certification is both. It's aimed at everyone there. We've got Phillips type claim construction for patents that are going to expire within 18 months of institution. I think that helps the patent owner because it does then incorporate the idea of construing the terms to preserve the validity of the patent. Word counts or page limits, I think the addition of word counts helps both parties, and I suspect it's going to help the PTAB judges as well. And similarly, the exchange of oral hearing demonstratives 7 business days before the hearing is going to benefit both parties. So while there are some things that benefit one party more than the other, it's difficult to say at this point whether they are a significant benefit or if it really doesn't change anything with respect to how often things are in IPRs and covered business method patent reviews are instituted.
Okay, thank you, Linda. So I think now is a good time to pause briefly and answer today's polling question. So at this time, I will read aloud the CLE course code for this program. If you are in need of CLE credit today, please enter the 5-digit code that I'm about to read into the polling question on your screen once it's announced. Please be sure to also press the submit button once you type in your response so that we are able to track your answers. Please note again that the course code will be read only twice. It is a combination of letters and numbers, so please pay close attention to that. The polling question will remain open briefly for about a minute or two to allow time for you to submit your answer. And as an additional reminder for those seeking Kansas, New York, and/or New Jersey CLE credit, in addition to the polling question we are about to complete, you will need to also complete the attorney affirmation form and return it by email to me immediately following the program. Again, a copy of the form can be found in your confirmation email as well as in the resource list widget. And as a reminder, my email address is ajones@foley.com. So now at this point, I will read the course code. The code is the number 3, followed by the letters I as in India, E as in Echo, O as in Oscar, W as in Whiskey. I will repeat the code once more. It is the number 3, followed by the letters I as in India, E as in Echo, O as in Oscar, W as in Whiskey. If you are seeking CLE credit for this session, please complete the polling question now by entering the code that I just announced. We will leave the poll open for another minute or so you can submit your answer, and then we will continue with the program.
Allison, are you letting us know when we should start again?
Yes, I was actually just about to say so. So at this time, the poll is now closed. I would like to return the program to our speakers. Thank you so much.
So just to quickly wrap up before we turn to any questions in our final minutes, we talked about the expansion of pre-institution practice as really being the most important change, and the ability of the patent owner to present new testimonial evidence in the preliminary response, which really could mean that in some cases there's a better opportunity for patent owners to prevent institution. And as we all know, that is the goal of patent owners, given the relatively high percentage of claims that are invalidated when there is an institution decision. We talked about the Rule 11 type certification that's now required for all papers starting on or after May 2nd, and the fact that motions for sanctions can be brought, and especially with the rule about disclosing information that is inconsistent with any argument that's been presented, that takes on heightened importance with this Rule 11 certification. We talked about the fact that there's no change to claim construction for now, at least, although we need to keep our eyes on quasi. And there is a procedure for the small group of patents that are going to expire right around the time the AIA proceeding is filed. So for any patent that's going to expire within 18 months of the accorded filing date of an AIA petition, it's possible for either party to request an alternative claim construction to broadest reasonable interpretation. The several procedural improvements have come along. There's more time to exchange demonstratives, and also the word limits for various filings in the procedure. And as I mentioned earlier, there's going to be changes to the trial practice guide coming, and it does always help to read the fine print that the Patent Office puts on these changes in the trial practice guide. So we'll certainly keep our eyes open for that. And that concludes our slides. And let me pull up a question or two here to see if, oh, go ahead.
I was going to say, I just looked at the first question that I had, which is, will the new rules increase the cost significantly? And I think the answer to that is, if in fact you are the patent owner and you want to put in the new testamentary evidence, yes, that's going to increase your costs. You'll have expert costs right up front, and you'll have the costs of briefing, essentially, a validity argument for your patent. So it will increase the costs, and it will increase them at the beginning of the process.
And I'm not sure we'll be able to get to all the questions that are being asked. I don't know exactly what our time limit is, but I see one other question from somebody about whether the board can already allow the petitioner an opportunity to reply to a patent owner's preliminary response. And that is correct. There have been IPR proceedings, although I think they're quite limited in number, where under the existing rules, the board has allowed a petitioner to reply to a patent owner preliminary response. In some cases, this may relate to challenges to real party and interest or some type of standing issue where the board feels it may be helpful to hear once more from the petitioner. But in general, I think the board has mostly not allowed such requests, and I think this new rule change may make it a little bit easier for a petitioner to obtain leave to reply, given that we're now allowing patent owners the opportunity to submit new evidence and new declarations. So it may not be a huge change from what we already have, but it does appear to be at least a reason why they may allow more petitioners the opportunity to reply.
Then there's another question, is 18 months a totally arbitrary time period unsupported by statute? And the answer to that is no. I assume that what you're referring to on the 18 months is the changed claim construction standard if the patent is going to expire within 18 months from institution. The reason for that is if you used the broadest reasonable interpretation claim standard and you said, well, that's okay because we're going to give you the opportunity to amend your claims, if the patent is expiring in 18 months, you're going to get to the point where you can amend the claims and, oh, by the way, the patent expired right now. So you don't then get any benefit at all from amending your claims. If the patent is going to expire with 18 months and they use the Phillips type standard, which allows for construction to preserve validity, then you have a chance of actually getting something out of your patent. So I think the 18 months is based on how long it takes to go through this procedure.
Agreed. I think that's probably all that we have time to answer in our program, but we'll certainly take a look at the questions and try to email responses to any questions we didn't get to. So with that, I'd like to thank everybody for joining, and thank you, Linda, for co-presenting today, and that concludes the program.
Thank you, everyone.
And just a few housekeeping notes again towards the end of the program, a few reminders for everyone. We do welcome your feedback, so there is a program survey that will pop up following the conclusion of the program. If you have a moment, please take some time and complete that questionnaire before leaving for the day. One final reminder for those seeking Kansas, New York, and or New Jersey CLE credits, you are required to complete the attorney affirmation form in addition to answering the polling question that was appeared earlier during the program. The 5-digit course code was announced earlier, so please email that course code with your completed form to me immediately following the program. And if you have any additional CLE questions following the program, again, don't hesitate to reach out to me. CLE process will take approximately 8 weeks, after which you will receive an emailed certificate of attendance if eligible. And finally, for additional information on this topic, you can stay up to date on the newest PTAB decisions and trends by subscribing to our informative Patent Office Trials practice blog entitled PTAB Trial Insights, and the web address is ptabtrialinsights.com. Again, thank you all for joining us. I hope you found the program very helpful, and have a great rest of your afternoon.